Number 63, the people of the state of New York versus Gary Thibodeau. Good afternoon, counsel.
Good afternoon, Your Honors. May it please the court, my name is Lisa Peebles. I represent Gary Thibodeau, the appellant in this action. With the court's permission, I'd like to request 2 minutes for rebuttal.
You may have 2 minutes.
Thank you. If a jury had heard the newly discovered evidence that had been presented to the lower court, Gary Thibodeau would be home with his family today.
Counsel,
Go ahead.
I was just going to ask the same thing. What's the standard of review? What's our standard of review here? They had an extensive hearing where many witnesses testified, I think including the 3 people now alleged to have done this, and it's affirmed by the appellate division. What's our standard for reviewing those conclusions?
The basis for the court's decision denying Mr. Gary Thibodeau a new trial was based on his abuse of discretion as a matter of law in applying the admissibility with regard to the evidence that was presented. So for our position is that the lower court made abuses of discretion as a matter of law when determining whether or not this evidence would be admissible at a new trial.
But can we review, so much of it, it seems to me in this case, rests on the trial court's credibility determinations and reliability determinations of the statements against penal interest. So how do we review those determinations?
Well, I'll give you an example in terms of how the court decided that for example, one statement that was against one of the 3 new suspects' penal interest, Chris Combs. He's called to testify at the evidentiary hearing about admissions by one of the new suspects, Roger Breckenridge. Roger Breckenridge, according to Chris Combs, and he testified to this, told him that he was involved in, we burned her body, we disposed of it in a van, and we shipped it off to Canada. The court said he placed no reliability on that because Chris Combs at the time didn't believe Roger Breckenridge meant what he said. That's not a requirement when you look at the Settles criteria in terms of reliability as far as admissions against penal interest.
That wasn't just it. I mean, there were also issues about whether there was corroborating evidence and that sort of thing. I think that when it comes to reliability, it was based on a combination of things.
When you look at the standard under the 4th prong in Settles, which it really is minimal when you look at it in terms of a statement against penal interest, it suggests that there's a reasonable possibility that the statement might be true. What did we bring forward to establish that these statements by these 3 new suspects to a variety of people who were not related to either Gary or Richard, didn't even know Gary or Richard, were related to one another and had been trickling in beginning from 2000? What did we show? We did find a cabin on Rice Road. We did have 3 different cadaver dogs, including a state trooper cadaver dog, who indicated for the presence of human remains. The court in its decision said that the expert who testified from the Massasauga Volunteer Rescue Center with her canine dog said could have indicated for the presence of human remains, but that's not what she said. She was unequivocal when she stated that her trained cadaver dog indicated for the presence of human remains. Now, what else did we have? We have Jennifer Westcott in a secretly recorded call that was monitored by law enforcement where she's talking about the 3 new suspects bringing Heidi Allen over to her house in a van. What did the court say about that? The court says it faulted the defense because we couldn't establish what happened to Heidi Allen after she was brought over to Jennifer Westcott's in the van.
But Westcott, I mean, I read the transcript of the call, right? And she didn't say very much on the recorded call. And she was all over the place. She not recanted exactly, but she denied what she said. And so doesn't that just really boil down to her credibility?
When The court determined that the recording would not be admissible because it wasn't a statement against penal interest. We disagree. Jennifer Westcott, during the call, acknowledged that she was involved in the disposal of the van.
Point, you disagree. So, you know, I might agree with you, but I'm not sure that's the question, because I'm not sure it's our place to second guess that. The appellate division is allowed to do that, but we can't get into those credibility issues.
When you look at the...
Counsel, what's the law question for why it's a statement against penal interest?
Because Jennifer Westcott admitted that she was involved in the disposal of the van with her then boyfriend, Roger Breckenridge. That's a statement against penal interest. And
That's a legal question to assess whether or not it satisfies that
that's a
standard.
legal question, correct.
It has nothing to do with credibility?
Nothing to do with credibility. And the court found that because that wasn't a statement against penal interest, it didn't meet the exception to the hearsay rule, the recording's hearsay, therefore you couldn't get it in a new trial. And the
Even if you're
fact
right
of the-
about, even if you're right about that statement, that doesn't get the whole recording in, right?
Well, I would argue, Your Honor, that it would be admissible under the defense right to present a defense and his due process right to establish third-party culpability under Chambers versus Mississippi. It would be a probative value. A relevant probative value would be outweighed by any prejudicial or delay in the proceedings. So certainly, Mr. Thibodeau would have a due process right to have a jury hear this. Now, what's interesting is Jennifer Westcott's reaction when she was confronted by law enforcement, which is videotaped, which we also offered as part of the evidentiary hearing, where she flat out denies ever having this conversation with Tanya Priest. When she's confronted that it was recorded, she thinks Tanya Priest recorded it. So she says, well, she chopped something. And then when they say, well, no, I heard the tape, we monitored it, then she said, well, I don't know what to say. I don't know what to say. Am I going to be in trouble? Those facts should have been permitted for a jury to look at. And the court precluded the defense from introducing this by suggesting it would be inadmissible because it didn't meet these hearsay exceptions. And that, in fact, is where the court erred as a matter of law. Again, we also had third-party culpability or reverse Molyneux evidence against one of the three new suspects who testified. All three of these individuals testified, and none of their denials to these statements were convincing. And at some point in time during the course of their examination by counsel, they tried to invoke their Fifth Amendment for a variety of reasons, whether it was sending a directive to Westcott to keep her mouth shut from prison, whether it was Steen talking about his drug distribution. Steen admitted on the stand that he learned after the fact that he may have hauled Heidi Allen's remains to Canada.
So you've sent out quite a lengthy list of what you see as the errors. Are there one, two, or even three that are the ones that you say, Your Honors, if you discount everything else, if you disagreed with us on everything else, here are the ones that show that the court abused its discretion by failing to grant the new trial?
Yes. First of all, the Jennifer Westcott recording, that's number one. The statements against penal interest that were through the testimony of Amanda Braley, Chris Combs, Tanya Priest, Jennifer Westcott's testimony.
You're kind of going through the whole list. So in your opinion, it takes all of them? We have to find that all of those were wrong?
No.
To show abuse of discretion? That's really what I'm trying to ask you.
The tape itself would result in
no.
a verdict.
What is the legal error on the reverse Molyneux? What is the error of law there?
The court held us to a standard, it failed to account for all of the evidence that we presented against Michael Bohr as a third new suspect, and looked at it like it's some freestanding propensity claim, which is not how we offered it. We actually brought in the victims and had them ready to testify from his prior attempted kidnappings and prior assault,
What
which
was the
almost...
modus operandi there?
Well,
That was common to everything and so unique.
the manner in which he was so brazen that he went right up to a woman and grabbed her and tried to shove her in his car, which the eyewitness that the people called to testify during the hearing.
And that's enough?
Well, when you look at it not so much as a freestanding claim of propensity, you have to look at the fact that Michael Bohr called
We're looking
in,
at admissibility.
he called in false leads. He began to cry during the course of the evidentiary hearing. He began again to sob when he talked about driving by the Heidi Allen sign. He said he wasn't capable of any violent acts, which is why he told law enforcement he could not have done this because he's not a violent person. All of this he said before the defense uncovered all of his prior acts.
Thank you, counsel.
Thank you.
Counsel?
Good afternoon. May it please the court. My name is Greg Oakes. I'm the district attorney for Oswego County. There are a number of issues presented to the court, and what I would like to do is address Justice Garcia's question regarding the standard review and Judge Stein. And I think you're exactly correct on those issues, that there is no standard review for this court because a lot of the questions and decisions that were presented to the hearing court relied upon issues of credibility and the reliability of those witnesses. And were actually factual determinations and a weighing that the court made, really focusing upon the weight of the evidence in two different respects. One,
What about whether or not a statement constitutes a statement against penal interest?
well, and those reliability determinations relate to the fourth prong, Your Honor. Again, in looking at whether there's a reasonable possibility that the statement may be true. Again, the court's been very clear and settles it's a reasonable possibility. So I think it's appropriate for...
What about the sheer number of these separate and seemingly unrelated confessions by these three men, and with some independent corroboration?
Well,
What do we make of that? I mean, does that have any does that have any result?
well, to your question, Your Honor, the fact that there are multiple statements, God bless you.
Thank you.
Multiple statements doesn't make the independent statements more admissible. The fact that a lie or an exaggeration is repeated multiple times doesn't make it inherently more reliable or admissible under the court. And part of the problem we received in this case...
It would be a factor, right?
Potentially a factor, but unique to this case is once the 440 motion was filed, there are a number of stories in the media. And in fact, it seemed that pretty much every affidavit, every video, every recording somehow made its way to Syracuse.com, was published online, and really polluted the entire pool. So when somebody came forward with information, we had no idea whether it was somebody who had actual credible information based upon their independent knowledge, if they were just reading stuff online and coming forward seeking their 15 minutes of fame. But coming back to you, Judge Rivera, on your issue on the reliability. When we look at, is there a reasonable probability that it being true, the court looked at the reliability of those witnesses. And again, when we talk about Jennifer Westcott's recorded phone call with Tanya Priest, as you said, Judge Stein, it was all over the map. There were inconsistent statements made even within that. And key in that, she said at one point, well, I don't know. I didn't actually see Heidi. I just took two and two together, and this is what I came up with. As the defendant has said in his motion papers, there is no actual evidence that Jennifer Westcott was involved in the kidnapping, the murder, or the disposal of Heidi Allen. She has no criminal liability under any of those theories. So if she has no criminal liability, what's the standard for admitting that phone call? If she doesn't have culpability, those aren't declarations against penal interest relative to her. But when we look at the reliability, the court looked at all the evidence that came in at the hearing to see whether there was any indication, anything that would make these statements potentially be true. Focusing mostly on James Steen, the court could look at the objective information that was developed during the trial. According to Tanya Priest, James Steen said he came in through the back door, that he and the other guys essentially rushed her in the store and forcibly carried her out. One, there was no evidence at the trial, and there's no evidence at the scene of a forcible abduction. There wasn't a newspaper, there wasn't a coffee cup or anything knocked over. But more
What about the evidence of the man who was driving by? Was it Pierce?
William Pierce, yes, Your Honor.
What about his evidence?
His evidence, again, comes down to a credibility determination. Mr. Pierce came forward after 20 years, and his initial statement to the sheriff's office was, "You got the right guy." I saw news reports shortly after this happened, and I saw that Gary Thibodeau had been arrested, and I believed, you got the right guy, and I'm coming forward so you have that certainty of knowing you got the right guy. And he steadfastly believed that so much, again, so he came forward on his own. It was only after seeing these reports in the newspaper, the unduly influential photograph of James Steen in his jail outfit related to his murder conviction, that he says, oh my goodness, I got the wrong person. But when presented of a photo array that was closer in time, a picture of James Steen closer in time, he couldn't pick him out. Now again, it wasn't from 1994, that photo and that photo array, but it was a lot closer in time than his photograph from 2010, 16 years after the fact. And when we talk about the issue of the standard of review and reliability and credibility, Judge King was in a position to hear directly the testimony of William Pierce. At times being confused, paused, hesitation, when presented with photographs that showed that he wouldn't have a correct vantage point to see what he claimed to have seen. Again, he initially indicated the van being in one spot and seeing one person. But when we talked to him about where he was and what he could have seen from that vantage point, suddenly it shifted a little bit. His excuse for not coming forward after all those years was either, well, I thought it was a domestic incident and I didn't want to get involved, to later on, well, actually, I just figured you guys had the right guy, so I didn't want to get involved. The court could hear firsthand his responses and was in the best position to make those reliability determinations, particularly when weighing his descriptions against, again, known evidence that was developed 20 years ago in the trial. I mean, as you talked about in the case before this one, if there had been a trial, if there had been a hearing where people could put forth evidence, well, we did that 20 years ago. And the deputies and officers testified about the weather. They showed photographs relating to the condition of the store. And Mr. Pierce's testimony conflicted with those known established facts. I don't know if in his heart he honestly believes it. But again, I think this is a man, again, of advanced age who's confused, having seen a photo in the paper, wants to believe he might have information. But again, those are credibility determinations left to the court that, with due respect, are beyond this court. But again, that really goes to the fourth prong of should it be admitted as a declaration against penal interest. And when we look at Steen's declaration, again, according to Tanya Priest, she said they went back to Roger Breckenridge's home on Rice Road. Well, there was no testimony that Roger Breckenridge lived at that address. In fact, one of the defense witnesses conceded, I knew Roger Breckenridge back at the time. He lived with his wife, Tracy, not Jennifer Westcott, and his kids on Kenyon Road, which ironically was about 2-3 miles down the road from where the defendant lived. The defense tried to show that Jennifer Westcott's mom may have lived there, but again, there's no testimony that she was living there necessarily. And again, it strains credibility to think that even if Roger Breckenridge had been dating Jennifer Westcott, which again, there's no evidence at that point, that he and his buddies would kidnap this young lady, take her back to his girlfriend's parents' place to a garage, it strains credibility. And again, when we look at the physical evidence that was developed, well, actually, if I could back up a moment, when we talk about them living at Rice Road, again, we established who actually did live at that residence. A young woman at the time, Darcy Purdy, she's now a legal secretary. She came forward and said, I moved in at the beginning of 1994. We had her lease that she signed in December of 1993. She said, I know I lived there. Here's my wedding registry. I had my bachelorette party at that residence, and I lived there continuously for a couple of years. And not only did I live there, I can tell you I did there, but here's mailings that I received at the time. Here's a card that I sent to my mom on Mother's Day at the time that's postmarked from that location. And again, if Darcy Purdy lived there, and again, there's clear factual evidence or proof that she did, then the whole Tanya Priest story doesn't make sense, because the entirety is premised upon that location at Rice Road.
So you're basically saying the way for us to look at the case is, you say what they presented is not believable. They say it is. Trial judge heard it, agreed with you, it's just not believable, or it's not enough, right?
I think that-
And there's not a question of law embedded in any of this for this court to decide that would be a basis to reverse the appellate division.
That's correct, Your Honor.
You know, there were three points that I think addressed
Judge Rivera's question about the specific instances that you would point to that Judge Sentra, in his dissent in the Fourth Department, identified as problem areas for the people. First, there was priest statements regarding Steen's admission. Second was Braley's testimony concerning Breckenridge's admissions. And the third was Combs's testimony regarding Breckenridge's admissions. You got a few seconds. Would you address those?
Thank you, Your Honor. Again, those are legal issues that are presented, but within those legal issues become a credibility determination, reliability determination, because this court said and settles, perhaps the most important aspect of declarations against penal interest is that fourth prong. Again, there's been no independent evidence, no competent physical evidence or other evidence outside of the declarations themselves to show that these statements are true. Again, I've talked about Tanya Priest's statement relating to James Steen with Amanda Braley. Again, her statement is really probably fails on multiple prongs, that he doesn't show competent evidence. But again, the statement is essentially, I'm never going to go to prison for what we did to Heidi. Well, it doesn't say what he did. We have no idea if it relates to this case or something else. But interestingly, this came out during cross-examination of Amanda.
And there are no inferences that can be drawn based on all of the evidence they presented?
There are perhaps some inferences that can be drawn, but when we talk about reliability, one of the issues that came out in cross-examination of Amanda Braley is, as part of the defense motion, they submitted an affidavit from Amanda Braley. Ms. Peebles, or one of her investigators, took that statement from her. That was submitted as part of their motion papers. In that statement, she never referenced the statement about, I'm never going to go to prison for what I did. I cross-examined her about that issue. And again, her explanation was, well, I did tell defense counsel, they just forgot to put it in there. Again, that itself strains credibility. And again, she's saying that she really believed these statements, yet she was with Tanya Priest in the woods walking. And if I may for a moment, Judge Wilson, you had talked about the Molyneux issue.
Yes.
Again, I think the court correctly decided those issues. There is no MO other than the fact of a broad sense of trying to abduct a female. There's nothing specific or particular about the manner in which that was carried out. And interestingly, to go to your point, Judge Fahey, again, the defense has limited their argument to those three statements or pieces of evidence for the purpose of this appeal. The defense has not argued before this court that any of the statements attributed to Michael Bohr should be admitted. Judge Sentra didn't find that any of the statements attributed to Michael Bohr should be submitted.
My question on the Molyneux was really a little different from what you anticipated. It's whether the defense needs to meet the same legal test that the prosecution would need to introduce Molyneux-type evidence.
And I believe they do, Your Honor. Again, showing that it either goes to intent or a motive or lack of mistake or modus operandi, that it was carried out in a particular fashion. Because otherwise, the defense is trying to introduce third-party culpability evidence. Could simply pick the worst guy in the jail, the worst guy in the community, and say, look, he's got these rape convictions, he's got these burglary convictions, all of that's going to come in, and it leads to juror confusion and takes away from the central issue as, well, did they commit this particular act?
But didn't they present evidence that the three are connected to this crime? That you could draw inferences to that effect, or from their own statements
Well, and again,
come to that conclusion?
well, this statement that James Steen made, again, according to Tanya Priest, implicated Michael Bohr. But again, I don't think that necessarily should be used against Michael Bohr. But again, all the statements are attributed to Michael Bohr himself. Again, the hearing court and the appellate division found didn't meet the standard for declarations against penal interest. And the defense hasn't even argued that either of those courts have erred. Again, before this court, they're not asking you to consider the admissibility of any of the statements of Michael Bohr. So the point I was going to make is, if none of those statements regarding Michael Bohr are being admitted, how does his criminal history come in? Because clearly he was being offered as propensity evidence to show that he's a bad guy, capable of violent acts, and you should just, jury, you should think he's a bad guy and did this particular act.
Thank you, counsel.
Thank you very much, Your
Ms.
Honor.
Peebles?
I'm just going to lead off with where Mr. Oakes ended, with regard to the Michael Bohr and the reverse Molyneux evidence. First of all, We have not abandoned any claim regarding any admissions made by Michael Bohr. Part of our argument to this court deals with the reverse Molyneux, and we're asking the court to consider it into context. We did not cherry pick Michael Bohr as a new suspect because we found that he had some prior attempted abductions and rape and attempted murder of other women. Michael Bohr's name came to light first in 2000, which the defense didn't know because Tyler Hayes called the sheriff's department and said this man is making admissions about the abduction of Heidi Allen. It concerned him. We never got that until we filed our 440 motion. Tyler Hayes reached out to us when he heard about it because he saw Michael Bohr's picture plastered on the media. Come to find out, he had tried to reach out to the sheriff's department back in 2000. Michael Bohr was thereafter interviewed prior to our motion by the Oswego County Sheriff's Department. During that interview, they said, well, people think you were involved in this. He throws out the fact that Heidi Allen's body might be somewhere in a junkyard, Crosby Hill, which just happens to be where Murtaugh's junkyard is, which is where Jennifer Westcott was sending text messages before she went to be interviewed by law enforcement. This information was presented, and there was no reason under the law why it should not be able to be presented to a jury so that a jury can determine whether or not it would make a difference in the outcome, and we think it would. Now, with regard to, again, Michael Bohr, he told law enforcement when he was being interviewed that he doesn't have the capacity, he's not a violent man, and that's why he couldn't have done this. Well, we found out that that wasn't true. He does have a very violent past. So we're not offering it as some sort of freestanding propensity. He did it once, he did it again. We're offering it into context that he lived a half a mile down the road. He said he went to the store every day, that Heidi Allen made him sandwiches. He collected a box of written materials he wrote himself. I tried to introduce those during the evidentiary hearing. The court would not allow me to introduce those documents. I tried to question him about the meaning behind some of what he wrote. He's living in an RV. He has this box on the 20 years later, he still has this box. So the people chalked him up to some nutball, not recognizing that the man is a psychopath who had tried to abduct and kidnap women in the past. And that's, again, it was not some sort of freestanding claim of propensity. As far as Pierce, the lower court found that Pierce's credibility determination with regard to Steen had no evidentiary value. What the county court failed to recognize was his identification of a van that didn't belong to Richard and Gary. That was the key because the van is unmistakable. The whole time they were investigating the case against Richard Thibodeau, they kept plastering the picture of the van all over the media. And Pierce's testimony, the critical component of his testimony, and the county court acknowledged he saw something. In the court's own decision, he said, well, what he saw that morning, he may be, but he wasn't persuaded by his identification of Steen some 20 years later. But the reality of it is the court conceded he was there and said he drove by, but he just couldn't, he talked about how he's put all these studies out there on how eyewitness identification is somehow flawed and his memory's not accurate, and he couldn't place any evidentiary value in that. But if the defense were able to call Mr. Pierce to testify about the fact that he saw a van and that wasn't the van he saw, it wasn't Richard Thibodeau's, that would definitely change the outcome of the trial. Thank you.
Thank you, counsel.